Or is there anything from the state's perspective, objection-wise, discovery-wise, about Dr. Lindsay? That's the...
We have absolutely no idea what Dr. Lindsay intends to say because we have some handwritten notes. It says red stop, top tube, and some more.
She's being called for what purpose, Ms. Holland?
She is a toxicologist who sent over a summary as requested to the state regarding what her subject matter would be. She is going to testify to the levels of concentration of cocaine, cocaethylene, and fentanyl in the samples of blood and urine of Jade.
She's going to be able to testify to an amount of cocaine that was taken?
She's going to be able to opine on the amounts that are listed on the toxicology reports and the litigation packets.
Okay, in terms of whether that they are numbers that you actually rely upon?
Correct.
Okay. So she's gonna be opining about what you asked Dr. When you got into the 500,000, 98,000, those kind of numbers.
No, I didn't.
No, I'm not talking about you, I'm talking about the state.
Judge, I'm sorry, I have the same standing objection that she shouldn't be talking about any work order that is not entered into evidence.
We don't
Okay,
plan to.
That's fine. I don't think they're doing that. So, and then on Dr. Larkin, you now have this document, right?
Yes, so
I'm asking the state.
Yes, sir. The report that we got today?
Right.
Yes.
So, is it the state's opinion that I can exclude Dr. Larkin from testifying because you just today got this document?
Yes, Your Honor.
Based on what?
On the prior motions that we filed last year, we have had, zero notice. She's typed a report. She's trying to opine as to the cause of death, and we have had no notice. Reciprocal discovery is, well,
Well, that's
Your
what
Honor was specific with them that if an expert was going to have a report, it had to be provided to the state pre-trial.
that,
Okay.
that is not a report. I did not get until today. The court asked us to reach out to
Where
our
is Dr.
experts.
Larkin?
She's right here.
Let her step up.
Stand right here, raise your right hand.
Raise your right hand.
I swear.
Do you need to do something?
You change out batteries.
Okay, go ahead. We've waited on everybody else.
Thank you.
Did you generate this two-page document?
Yes, sir.
When?
This weekend, I guess.
And you gave it to who?
I was asked this morning to send
Gave
my
it to who?
notes.
You didn't give it to anybody this weekend?
No, I did not.
Why did you compile this two-page document?
That is the way that I approach when I'm going to do something like this. In my
Why
mind, I
wait
need
till
to.
the last minute?
Yes, sir.
Why is that?
Because I'm going through what I've put together over time, and when it gets closer to me going to testify, I want to make sure that I clearly and concisely put my points. I was an engineer before I was a doctor, and
Okay,
that's how I
so
approach
when did
problems.
you send this to anybody?
This morning I was asked for notes, and so those are the notes that I have. So I sent those when I was at the airport this morning, about 10:30 maybe, and I sent that to Letitia and her team.
Okay. Any questions from the state?
Dr. Larkin, how long have you been working on this?
That was just very quickly putting that together.
No, she didn't ask that. You're talking about the case?
Right, how long you said that you just at the end put your analysis together that you've been working on. How long have you been working on your analysis?
I think I got asked to, I think when originally they were in Nashville a few months ago, I was told about the case, and then more recently, I've done work on reviewing all the records, and that's probably within the past month or two. I don't know for sure, but more recent. It hasn't been years or anything.
Okay, so maximum 2 months, maybe a month, you've been reviewing records related to this case.
Approximately. I don't know exactly when I started. I'd have to look at when I started getting some information, but
Do you have documentation about that with you?
I don't have it on me. I could find that out, but it's been several months.
Okay,
I would say on the outset, if you want a number, maybe, several months, something like that.
Well, you said 1 to 2, and now you're up to several. Which one is it?
Yeah, I'm gonna object to this line of
Okay.
questioning
Yeah.
with this.
Is there something in your phone or something you have today that you could tell us? Look up and tell us.
I can tell you.
Okay, yes.
We reached out to her prior to the last trial. She was not officially retained at
That
that
was in
time.
January.
Yes, it was.
Okay.
However, she did not start actually digging into the trial until probably maybe 2 to 3 months ago, before she got everything that she needed.
Okay, what other questions do you have?
Did you take notes along the way?
No, I don't. I mean, I guess I put the notes into there. I don't have any other notes that I've taken, if that's what you're asking.
So no other notes, and you put that together this morning,
She
No,
said
ma'am.
this weekend, last weekend.
Yes,
last weekend, but you didn't send it to anyone?
I did not until today.
Were you instructed to not type up a
Yeah,
report?
I object. I object to that line of questioning, because what I tell my expert is confidential from Mr. Taylor and his constitutional rights. She
Do you
doesn't.
have any other questions other than that?
Not at this time, Your Honor.
All right, thank you.
Thank you, sir.
Have a seat. Okay, here's what Rule 16, the Rules of Discovery under the Tennessee Rules of Criminal Procedure say, dealing with information subject to disclosure by defendants. Inspect and copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions of these, if within the defendant's possession, tends to introduce them. That's part A of that B1A. In terms of our discussion about what a report is, that's under B, where it says reports of examinations and tests. And the pertinent parts say that the defense has to disclose upon the defense asks for discovery, then the defendant has to comply with reciprocal discovery, which the rule says inspect, copy, or photograph any results or reports of physical or mental examinations. That's what all the appellate cases mainly deal with, is insanity, mental health examinations, and of scientific tests or experiments made in connection with a particular case or copies thereof, if the item is within the defendant's possession, custody, or control, or the defendant intends to call as a witness at the trial the person who prepared the report. So, does this document deal with scientific tests or experiments?
Judge, she's giving her opinion based on the review of the tests.
Right. But did she do any scientific tests or experiments?
Well, I mean, I don't know, not that I'm aware of, but she refers to laboratory testing confirmed.
Okay. But then on the second issue, if it should have been disclosed, it didn't exist till this weekend, which this is, what is this, Tuesday? So the state could have gotten it 48 hours earlier. So we get to the bottom line of, if there's a failure to comply with the request, the court may order that the party to permit the discovery inspection. It's already untimely for that. Grant a continuance, prohibit the party from introducing the undisclosed evidence, or enter such other order as it deems just under the circumstances. So,
May I be heard?
if, I haven't finished yet. If there is, I'm not sure there's a violation of Rule 16, but if there's a 48-hour violation, what is the state seeking the court to do?
Judge, we're asking that it be excluded just as we did in our pretrial motions.
Okay, but even fall under Rule 16.
It's your decision.
Did you carry her?
I do. How do I turn over something that I don't know exists? There's an email at 10:53. So it's not a report. She has done no scientific testing. She has done nothing of the sort. She made notes for herself to prepare to testify. The court tells us, reach out to our people, find out if they have notes. Today is Monday. I'm in the middle of trial, questioning witnesses, trying to get all the experts together to give the court what it asked for. That's difficult to do when I'm direct examining and putting on my case in chief. So at the break,
48 hours if she did it on Saturday, which I don't, she wouldn't ask specifically. Go ahead.
and so we're complying with what the court asked. She didn't call us and tell us that's what she was doing. And as I stated, it's not even a scientific test. It's nothing that she conducted any type of test on her own. We don't intend to introduce it into evidence. So I don't understand what it is that we've done wrong.
Okay, anything further?
Judge, I have a secondary objection,
Okay.
depending on if you are going to allow it.
All right.
The state has a couple of other issues with this report that is notes or report, whatever it is. Her report relies on information that is inaccurate and it's not in evidence. And it's specific to that urine test that Ms. Hollins keeps attempting to ask all these witnesses about that is not in evidence. And the state is, again, asking that she not be allowed to testify to any of the lab reports that are not in evidence, but she based her opinion on a lab result that is incorrect. She also is opining as to the cause of death in the state's position is she's not qualified to do that.
I don't know. Said she's an ER doctor. Where are you referencing a specific date about a urine screen?
So on her handwritten notes, it's kind of,
Oh, I don't have,
Oh,
oh,
I'm
who are
sorry.
you referencing?
so
Dr. Lindsay?
Dr. Lindsay references that drug sample, and then Dr. Larkin, I believe, also references the urine sample. Right, it's on the bottom of page
Fentanyl
2.
was detected in a urine specimen that was collected before fentanyl was administered in the emergency department. Is that what you referenced?
Yes, and then it says, therefore, the fentanyl identified in the specimen could not have originated from the hospital treatment, and instead indicates fentanyl exposure before her arrival at the hospital. And then she goes on in the third page, in the second paragraph, to talk about the opioid epidemic that has spread.
Yeah, I mean, I'm not gonna let her testify about that. What about is that next to last and last sentence on page 2 accurate, Mrs. Holly?
I believe that that is a question for the trier of fact. We were given discovery in this case, and when we were given discovery in this case, up until 10 days ago, the date on those lab reports were 2/25/23.
Didn't
10 days before trial, they
Didn't
changed
this-
the date, and now we're precluded from being able to utilize that date.
well,
So we believe that's an issue for
the
the
other
trier of
screen
fact.
wasn't tested, right?
All of them were tested, all of them.
Which one? I thought the Dr. Ruccoleri said no one that's been here tested that.
No one what?
No one has testified to the test result.
The work order 090 that went to some other lab hasn't been testified about.
Yes, it has been.
From who?
Katolsky, I believe it was. Dr. Katolsky.
Judge, we're referring to NMS work order 230788883. That is the one that this report is referencing, had a 2/25/2259 date. That is inaccurate. We did not correct it 10 days ago. We sent information to the defense months ago about the error on this date. We had the report corrected only in the event that it was somehow admitted during the trial, so we would not be sending
Did Ms.
inaccurate
Smith,
information.
from your deposition you introduced, say there was no fentanyl administered?
Correct, as well
I'm
as,
asking Ms. Holly.
Exactly. So what that means is when that urine test was tested.
What
when
urine
it-
test?
The urine test that was tested before she was administered in
By
the
who?
blood test. In the blood test.
Tested by who?
Tested by NMS.
no, NMS did not
No,
test that.
They didn't.
It was CFSRE.
See, that's where this
Since when,
courtroom's
Judge?
full of
Since when does a
confusion.
prosecutor call a lab and be able to change a medical record and we have to adhere to it?
No, I'm just asking you, is there proof
No, there's
that
no
you're
proof.
asking your expert to testify about?
Yes, for the last
Bring
3
back
years.
in Dr. Larkin. We'll figure what work order she's given this opinion about. General Norman in the work orders that no one's been here lab-wise to testify about?
NMS 23073.
230.
78883.
You're gonna be able to testify without anything in front of you?
No, and no.
Well, my question is anything in this document, 3-page document, that has anything to do with work order 2307883?
I don't know. I think Dr. Yancey's in the back.
Who?
You're looking at the document that I submitted, not Dr. Larkin.
Why are you standing up?
Because.
Just have a seat.
Okay, I think, so
Just have a seat.
I don't have any
You
reference
see
to any
those
work
last
orders
two
in there.
sentences in your report?
It's not a report though, right? Yes, I see that.
Where did you get that information from?
From the toxicology records that I looked at.
From who? What lab?
I would have to look. I can't remember. These are just notes that I have.
How are you going to testify? What are you going to use to find that out?
We will put those up when we
We
can put
will.
up the notes. I can ask to have that
She's
put
speaking
up.
about me.
What? So you have no clue where you got that information?
I got them from I have all the toxicology reports and I have summaries. I would have to look exactly where it came from.
Okay,
If
do
this
that.
were a report, it would actually have reference to that.
Okay, well, tell me where that information came from.
I would have to have the reports
Do
and
that.
pull it up.
Where is it? Is it the same report you asked about earlier or this
Well, I
one?
can share this with you. What I plan to testify or have her testify about is
Where is
I'm
the-
alleviating your issue.
You're not asking her about those last two
I'm not.
sentences? Oh, you said earlier you were.
No, I didn't.
No, sir.
Then why'd you put this in this document?
As she stated.
Those are just-
I'm not asking
notes.
you.
Those are just notes for me to
So
look
you
at.
didn't rely on
I've
this-
never ever
You
actually
didn't rely
produced
on
something
this
like
last
this.
paragraph for any of your opinion.
Not for what I'm going to be testifying to. No, those are just some of my thoughts I put
Okay,
down.
why don't we do this?
If
You
I had-
ask her what you want her to testify about.
I'm going to tell you, she's not prepared right now to testify for that because I don't have my things together yet. She's going
What
to
do you
testify.
need to have together?
I'm going to tell you what the 2 reports that she's going to testify to.
Okay, give us those.
I don't have any problem with that, sir. 231-26889 is one of them. And then 231-29285.
Your Honor, that's the first blood in the comforter.
Okay. You have issues with that?
I do not have issues with that. I do have issues with this witness whose non-report that I consider to be a report relies upon false information. And
I don't know. Let me try to find out again. Your opinion that says the history, witness observations, clinical presentation, toxicology findings, and objective medical evidence support the conclusion that Jade's collapse is more consistent with respiratory arrest resulting from combined cocaine use and pre-hospital fentanyl exposure than with a primary sole cocaine-induced cardiac event. Is that your bottom line?
Yes, sir.
Where do you get the information that there was pre-hospital fentanyl exposure?
Clinically, I can tell you in my 30 years of experience in treating patients with different types of overdoses, we have a clinical picture. We have the 911 call. We have the other witnesses that have spoken. We have the EMS.
You're talking about the sleepy, awake, talking, doesn't feel right, that kind of
Yes,
stuff.
and then and the two reports that we'll be talking about on the comforter.
So the,
And unfortunately, it wasn't tested for and everything.
what was it tested for?
She's not privy to it because I haven't had the opportunity to meet with her, which I had planned to do tonight.
What
The
was it
state-
tested for?
Not everything about fentanyl was not necessarily tested for, and
On what?
in the urine that's no longer done at 225.
But that's what I'm asking. You said you included your toxicology findings in making that opinion.
Your Honor, what is unfair is she's telling you that those are notes. Those are not her lasting opinions. That is not a report. So you're trying to commit her to something that she never intended to be that. So that's unfair to ask her for that. She has stated as a medical professional
She
doctor.
put, why
Those are
did you
her
include that paragraph?
notes. Those are her notes.
Those are just some of my thoughts. It doesn't mean they were
So
what
this
I'm.
paragraph on the bottom of page 2 means nothing to your opinion.
I'd have to look at it again. I just made some notes, and I probably put, I mean, that's not the basis of my opinion, but again, they're just notes. They're nothing official. There's no report. I don't write a report that looks like that. I just was asked to give some notes, and there were some things I just put together this weekend. And
So you don't know, Ms. Hollins, that you plan on asking her about any pre-hospital fentanyl use?
Yes, I do, because it was in the vomit. Their own witness testified that the vomit was the fentanyl was in the
From the
vomit.
lower level and all that.
It's hard, it's really hard. But what I'm saying is that the fentanyl was found in the vomit. That was testimony that came from that
But you don't
state.
plan on asking this witness anything about that other work order?
No, I don't.
Okay. Any other questions?
Yes, Your Honor. The state, number one, that was not Dr. Mithen's testimony. Dr. Mithen was very specific.
Okay, do you have questions of this witness?
Yes, this witness's notes include a reference to the EMS guy said he thought it was an allergic reaction. We do not have those facts in this case.
Where are you referencing?
That is the last sentence in the first paragraph. Our EMS witnesses said the exact opposite.
Well, here's what I can't do. And again, if she testifies tomorrow in front of a jury on inaccurate information, then again, you have the Perry Mason moment and say, everything you've said, if it's based on inaccuracy, would be inaccurate. But she may not be asked that, so I don't know. So we'll have to wait and see what she's asked, and go from there. Anything else?
Your Honor, may I ask that Dr. Carney we be able to watch her testimony if she testifies tomorrow
Sure.
remotely so that she doesn't have to be down here because she's been here all
Oh, I
afternoon?
get that, but it's important. She's willing to do that. We try like we did the direct link. I don't know what happened there.
I think he said he resolved it, right?
Sir, you will have latency like she did today. It all depends on their
Yeah.
bandwidth.
Just get with that gentleman and provide that link to Dr. Carney. Is she gonna be out of town or something?
I don't know, I just know that
She's
she has
welcome
a
to
job to
be
do
here.
because she does autopsies.
Well, she's employed by Davidson County. If you think she needs to be here, then have her here. All right, thank you, ma'am. You can check
Thank you.
that. All right, we'll be then in recess until 9 a.m.